Presentation 4 in the Management of People section of the course is all about employee relations. Now, it's really important to note that for the current year 2020-21, this does not have to be learned by students. This is not going to be part of your final assessment material. However, for future years, I'm just going to carry on with it anyway. The learning intentions for this particular unit are understanding the role of the different parties in an organisation when it comes to employee relations, who's actually involved when we're talking about the relationships in an organisation, being able to identify different forms of industrial action that employees can take, and describing the role of ACAS in employee relations. So employee relations, what do we really mean here? Well, good employee relations helps organisations to run smoothly and meet objectives. Employers have a duty to consult with employees and take part in fair negotiation before any changes are made. So the right thing for employers to do is to maybe run things past your employees, chat to them about things, have a kind of democratic style of management, allowing employees to be part of the negotiating process. However, what's really important to note here is employers are under no obligation to listen to employee demands. So disagreements and disputes in the organisation will arise. Employees won't be happy with the way that employers have brought in, for example, new shift patterns or for working conditions they're having to work in. For example, during the current coronavirus pandemic, it could be that employees don't feel safe at their place of work because they don't feel that employers are putting in the right health and safety legislation to allow them to feel safe. So things like that could arise and result in disputes. In order to represent both sides fairly, both sides, the employer and the employee, there are support groups available for both parties. Employees tend to fall back to trade unions, so employees can join a trade union who will make sure that they are protected, they are supported, and when any disputes or disagreements arise. As far as the employer is concerned, then they have employer associations. One of these would be the CBI, the Confederation of British Industry, which makes sure that employers are obviously looked after. So for example, once again, during this current pandemic, you'll find that the CBI will be there to fight for employers because employers are having to spend a lot of money and take a lot of time to put these particular protocols into place. And the employer associations will be making sure that they perhaps approach the government to make sure that the organisations are recompensed for this or given some kind of grants, etc. ACAS is a third party, and ACAS is around, they exist when no agreement can be reached between employers and employees, when they've reached a stalemate situation. Now, what's really important, first of all, to note here is that there is a difference between a grievance and a discipline procedure. Now, I'm going to say something really silly here, but it's really important to note that grievances are not when someone in the organisation has died. It would be unreal to imagine how many people in an exam situation will say that a grievance, people do grieve when someone dies, but a grievance is where there has been a dispute between two employees in an organisation or the employer and one of the employees or a number of employees. And grievances tend to be initiated by the employee. One employee if it's two employees, or the employee if it's between the employee and the employer. So grievances are where you're having an issue with another member of staff or your employer and you want to put it in writing so that it can be dealt with. Disciplinary procedures are designed to provide fair treatment of misconduct by an employee. Now that could be, for example, persistent late coming, insubordination, where you're perhaps not being respectful to your boss, things like that. And these could result in ultimately an employee being sacked, being fired by an organisation, but in between that there could be a lot of other things that can take place. If you're persistently late, you could be given some verbal warnings, it may become a written warning. These tend to be initiated by the management or by the employer. The disciplinary process then, so we talked here about some things that can be put into place when an employee is being disciplined by his or her organisation. A verbal warning is really where the manager and the employee have a face-to-face conversation about the employee's performance. So it could be about their persistent late coming. It could start off quite nice with, is there anything we can do to help you? Are you having problems at home? If it persists, then obviously these have to get a bit stronger. It may result, if things don't change, in something called a written warning, and this is where the warning is issued in a letter or some other written form, which makes it a lot more formal. When you get your final written warning, now different organisations can do this in different ways. You will find that if the offence is serious or it's a repeat offence, then you might find that you get what is called a final written warning. Now what that really means is after this we're then talking about you being suspended, with or without pay. Suspended means you're told not to come into work. They may pay you, they may not. Other things that can happen after you've had this final written warning could be that you're demoted. So it could be that you're perhaps in a position of authority and they've now decided that yes, they're going to continue employing you, but in a lesser position. So you may lose your position of seniority in the organisation. And it could be that you're dismissed or fired, which means the offence is serious enough that the employee is actually going to lose their job. So now we're going to look at trade unions, and trade unions represent the employee, as we mentioned a few slides ago, when negotiating things like working conditions and rates of pay. It's very, very difficult for an employee to take something on themselves and they may feel that they wouldn't be heard. So trade unions are there in order to represent the feelings of the workforce. There are different unions to represent different groups of workers. For example, in teaching we have a number of unions, the EIS, the SSTA, you've got the UWT, all of these are examples of trade unions. As I said before, trade unions are more able to push for a cause, for higher pay, for better working conditions than one individual person, and we call this collective bargaining. If they can do it as a group, then you'll find that it's maybe got a lot more clout, it's got a lot more push than just one person doing this on their own. Employer associations, on the other hand, are set up to look after the interests of all businesses in a particular type of industry. So for example, they would represent the employer during negotiations. So there have to be two sides of the story here, and the employer associations will represent the employer. The CBI is a body set up to represent employers from all sectors of the UK industry and commerce. So for any business in the UK, the CBI is there to represent the employer. Employee participation is quite important here, and it's set up to promote positive employee relations, so ways in which employees can actually take part in the workings of the organisation and feel part of it. And works councils are one of the ways in which they can do that. Now these can also be looked at as a motivator, so this is really important, that if you're talking about motivation, one of the ways in which you can motivate your staff is set up works councils. And what these do is these set up positive employee relations. They're made up of equal numbers of managers and workers, and they discuss any changes in the organisation before they're implemented. Worker directors are another part here, and what these are workers are actually elected to sit on the board of management and contribute to decision making, which seems rather strange, but it does happen. These guys are given maybe low-level workers, and they're given a seat on the board of directors. Now what's really important here is they don't have voting rights, but they can present their views and the views of fellow workers to the board. So they may feel that, a bit like a works council, you're taking things forward, but you're sitting with the board at this point, with the board of management, and you're maybe able to suggest things that could be done to improve the organisation. You don't have a vote when it comes to voting time, but what's really good about it is employees feel that they've got a say in decision making, which is quite important. The last thing we've got here are these things called consultative committees. And employers will use these to engage with employees. Employees will feel included in decision making, basically consultative. They may set up a committee, very, very similar to works councils, where they'll ask employees what their views are on a particular aspect, and it means that employees can then give their views and employers can gather these views on a wide range of different actions that could be taken in the organisation. It's much easier to progress decisions and changes in a business when employees are on board. So if you can use these different methods, works councils, worker directors, consultative committees, for all of them, it's easier to progress decisions if you feel that employees are on board with what you're trying to do. Industrial action is the next one, and obviously if this agreement can't be reached between employees and employers, then industrial action can take place. Now, industrial action is not just strike action. There are other things that you can do as well as that. For example, you could have an overtime ban, and that means that you refuse to do any overtime. Now, that might seem a bit crazy and the employee's been hit in the pocket. However, if the organisation's maybe trying to get orders out at certain times of the year when it's really, really busy, and employees refuse to do overtime, it could be a way for employers to sit up and take notice of the fact that the employees are not happy. So overtime bans can be quite effective. A work to rule means that you'll only carry out the tasks that are in your contract or your job description. So what that means is if someone is maybe off and the employer is wanting you to do something and you feel as though you're maybe feeling that there are decisions being taken in the organisation that you're not happy with, then a way in which you can get to the employer is by saying, well, no, I'm actually working to rule, which means you're only working, doing the tasks and the duties that are contained in your job description. Strike is the obvious one, and this is where employees refuse to work. You find that a ballot of members has to take place, it has to be done properly, and the majority of employees have to want to go on strike before this can go on. And then they will decide which particular day or days that the employees will not turn up to work. Workers can choose to turn up at the workplace and form a picket line outside the organisation to show others that they're not at work. And what they're then trying to do is they are trying to discourage other people from going into the organisation. People perhaps making deliveries, etc., that could actually detrimentally affect the organisation. Employees are not paid for the days that they're on strike. And we've also got a go slow, which is where employees will only complete their tasks. They will complete their tasks, but at a much slower rate. Once again, this could be really important if the organisation's in a hurry to try and get products or orders out, and employees are maybe not working as hard as they can in order to do that. This is just a little task on brainstorming that would have been done in class on employee relations, and you were asked to, with a partner, draw a spider diagram showing the impact of both positive and negative employee relations. It's really important to know how negative employee relations affect an organisation and its workers, and the same for positive employee relations. This is really important to know. So what is the impact of employee industrial action then? There's a loss in production, which will lead to the business being unable to meet demand. There'll be a loss in sales revenue and fixed costs. For example, rent, manager salaries. These all still have to be paid while no income is being made. There'll be a long-term loss of customers who now shop elsewhere at competitors and don't want to return. And the image of the organisation could be tarnished, and it could have a long-term damage to its reputation. There's also there could be a loss in confidence by investors, which means that they may not want to buy shares anymore. Shares might be sold, and an excess of supply of shares on the market will mean that the share price will fall, which doesn't make the organisation look very good. And it can also damage the relationship between the employer and employees in the longer term, because they may hold a grudge against each other, which could have a huge impact on how the organisation works. Now we're going to talk about ACAS, and ACAS is the Advisory, Conciliation and Arbitration Service. This was set up in 1975 to help improve employment relations when employers and employees could not agree. It can be involved in cases of unfair dismissal, where employees feel they lost their job unfairly, discrimination and redundancy. This is just a slide on the mission statement of ACAS to give you an idea of what it does. The mission of ACAS is to improve the performance and effectiveness of organisations by providing an independent and impartial service, that's really important, to prevent and resolve disputes and to build harmonious relationships at work. And that indeed is ACAS's job. So what is their job then? What does the ACAS stand for? They give advice on all work-related matters, for example, legislation. So people can go to ACAS and ask for advice on certain matters that could result in a dispute between employers and employees. So both employers and employees can go to ACAS and ask for advice. Conciliate is really where you act as an independent third party. So you are trying to get the employer and the employee to come together. It could be through the employee's union rep, to come together and start to discuss where things have gone wrong and how things can be improved. And that's what we call conciliation. There can be a little step there which is similar. They can try to put forward a basis for settlement, so they can try and get the two to talk together, and they can maybe come up with them both agreeing on where they can go forward with it. However, if none of this works, then arbitration steps in, and this is where ACAS acts as a court of law, really. And what they do is they listen to both parties, they make a decision and offer a solution which both parties will have to accept. So when ACAS make the decision, it's really, really important that both parties understand they have to be part of that decision. This was just another wee task where you were asked to go onto the ACAS website and have a look at the different aspects of employment that